Okay, we're going to keep going in contracts, but we're going to start with section 79 in the restatement of contracts, I should say. 79 is the adequacy of consideration, mutuality of obligation. If the requirement of consideration is met, there is no additional requirement of A, a gain, advantage, or benefit to the promisor, or a loss, disadvantage, or detriment to the promisee, or B, equivalence in the values exchanged, or C, mutuality of obligation. Section 80, multiple exchanges. There is consideration for a set of promises if what is bargained for and given in exchange would have been consideration for each promise in the set if the exchange for that promise alone. Okay, I'm on the wrong page. I really just wanted to return, I think, to conditional promise. Section 76. Number 1, a conditional promise is not consideration if the promisor knows at the time of making the promise that the condition cannot occur. And 2, a promise conditional on a performance by the promisor is a promise of alternate performances within section 77, unless occurrence of the condition is also promised. So, illusory and alternative promises is the title of section 77. A promise or apparent promise is not consideration if by its terms the promisor or purported promisor reserves a choice of alternative performances, unless A or B. A, each of the alternative performances would have been consideration if it alone had been bargained for, or B, one of the alternate performances would have been consideration and there is or appears to be to the parties to be a substantial possibility that before the promisor exercises his choice, events may eliminate the alternatives which would not have been consideration. All right, that made sense. Section 78, voidable and unenforceable promises. 79, I just read, adequacy of consideration, mutuality of obligation. 80, multiple exchanges. 81, consideration as motive or inducing cause. And then we will enter topic 2, contracts without consideration. One thing I wanted to... I did want to read this here because you see in section 82 the promise to pay indebtedness, effect on the statute of limitations. A promise to pay all or part of an antecedent contractual or quasi-contractual indebtedness owed by a promisor is binding if the indebtedness is still enforceable or would be except for the effect of a statute of limitations. 2, the following facts operate as such a promise unless other facts indicate a different intention. A, a voluntary acknowledgement to the obligee admitting the present existence of the antecedent indebtedness, or B, a voluntary transfer of money, a negotiable instrument, or other thing by the obligor to the obligee made as interest on or part payment of or collateral security for the antecedent indebtedness, or C, a statement to the obligee that the statute of limitations will not be pleaded as a defense. What I really wanted to read out of this contracts without consideration section is 83, titled Promise to Pay Indebtedness Discharged in Bankruptcy. An express promise to pay all or part of an indebtedness of the promisor, discharged or dischargeable in bankruptcy proceedings begun before the promise is made is binding. Because we like to sometimes know about that in the banking field. Section 84, promise to perform a duty in spite of non-occurrence of a condition. Except as stated in subsection 2, a promise to perform all or part of a conditional duty under an antecedent contract in spite of the non-occurrence of the condition is binding, whether the promise is made before or after the time for the condition to occur, unless A, occurrence of the condition was a material part of the agreed exchange for the performance of the duty and the promisee was under no duty that it occur, or B, uncertainty of the occurrence of the condition was an element of the risk assumed by the promisor. 2, still within promise to perform a duty in spite of non-occurrence of condition. 2 is if such a promise is made before the time for the occurrence of the condition has expired and the condition is within the control of the promisee or beneficiary, the promisor can make his duty again subject to the condition by notifying the promisee or beneficiary of his intention to do so if A, B, or C. A, the notification is received while there is still a reasonable time to cause the condition to occur under the antecedent terms, or an extension given by the promisor, and B, reinstatement of the requirement of the condition is not unjust because of a material change of position by the promisee or beneficiary, and C, the promise is not binding apart from the rule stated in subsection 1. So, section 85, promise to perform avoidable duty. That one's interesting. A promise to perform all or part of an antecedent contract of a promisor previously voidable by him, but not avoided prior to the making of the promise is binding. And section 86, promise for benefit received. 87, option contract. An offer is binding as an option contract if it A, is in writing and signed by the offerer, recites a purported consideration for the making of the offer and proposes an exchange on fair terms within a reasonable time, or B, is made irrevocable by statute. Section 88, guarantee. A promise to be surety for the performance of a contractual obligation made to the obligee is binding if A, B, or C. A, the promise is in writing and signed by the promisor and recites a purported consideration, or B, the promise is made binding by statute, or C, the promisor should reasonably expect the promise to induce action or forbearance of a substantial character on the part of the promisee or third person if the promise does induce such action or forbearance. Section 89, modification of executory contract. A promise modifying a duty under a contract not fully performed on either side is binding. A, if the modification is fair and equitable in view of circumstances not anticipated by the parties when the contract was made, and B, to the extent provided by statute, and C, to the extent that justice requires enforcement in view of material change of position and reliance on the promise. Section 90, promise reasonably inducing action or forbearance. 91, effective promises enumerated in section 82 to 90 when conditional. If a promise within the sections 82 to 90 is in terms conditional or performable at a future time, the promisor is bound thereby, but performance becomes due only upon the occurrence of the condition or upon the arrival of the specified time. 92 to to whom promises enumerated in section 82 to 85 must be made. The new promise referred to in 82 to 85 is not binding unless it is made to a person who is then an obligee of the antecedent duty. Section 93, promises enumerated in 82 to 85 in ignorance of facts. A promise within the terms of 82 to 85 is not binding unless the promisor knew or had reason to know the essential facts of the previous transaction to which the promise relates, but his knowledge of the legal effect of the facts is immaterial. Section 94, stipulations. A promise or agreement with reference to a pending judicial proceeding made by a party to the proceeding or his attorney is binding without consideration. By statute or rule of court, such an agreement is generally binding only if A, B, or C. A is if it is in writing and signed by the party or attorney, or B, if it is made or admitted in the presence of the court, or C, to the extent that justice requires enforcement in view of material change of position and reliance on the promise or agreement. Okay, so now we have reached contracts under seal, which is the introduction of the statute of frauds, and this is going to lead right into our prior discussion. Section 95, requirements for sealed contract or written contract or instrument. 1. In the absence of statute, a promise is binding without consideration if it is in writing and sealed, and the document containing the promise is delivered. And C. The promisor and promisee are named in the document or so described as to be capable of identification when it is delivered. When a statute provides, in effect, that a written contract or instrument is binding without consideration, or that lack of consideration is an affirmative defense to an action on a written contract or instrument, in order to be subject to the statute, a promise must either A or B. A, be expressed in a document, signed or otherwise assented to by the promisor and delivered, or B, expressed in a writing or writings to which both promisor and promisee manifest assent. 96, what constitutes a seal? A seal is a manifestation in tangible and conventional form of an intention that a document be sealed. A seal may take the form of a piece of wax, a wafer, or other substance affixed to the document, or of an impression made on the document. 3. By statute or decision in most states in which the seal retains significance, a seal may take the form of a written or printed seal, word, scrawl, or other sign. 97. When a promise is sealed, a written promise is sealed if the promisor affixes or impresses a seal on the document or attempts to seal already thereon. Adoption of a seal of delivery. Section 98. Unless extrinsic circumstances manifest a contrary intention, the delivery of a written promise by the promisor amounts to the adoption of any seal then on the document which has apparent reference to his signature or to the signature of another party to the document. 99, adoption of the same seal by several parties. A number of parties to the same instrument may adopt one seal. Section number 100, recital of sealing or delivery. A recital of the sealing or of the delivery of a written promise is not essential to its validity as a contract under seal, and is not conclusive of the fact of sealing or delivery unless the statute makes a recital of sealing the equivalent of the seal. Delivery. A written promise, sealed or unsealed, may be delivered by the promisor in escrow conditionally to the promisee or unconditionally. Unconditional delivery, section 102. A written promise is delivered unconditionally when the promisor puts it out of his possession and manifests an intention that it is to take effect at once according to its terms. Section 103, delivery and escrow, conditional delivery to the promisee. 1. A written promise is delivered in escrow by the promisor when he puts it into the possession of a person other than the promisee without reserving the power of revocation and manifests an intention that the document is to take effect according to its terms upon the occurrence of a stated condition, but not otherwise. 2. A written promise is delivered conditionally to the promisee when the promisor puts it into the possession of the promisee without reserving a power of revocation and manifests an intention that the document is to take effect according to its terms upon the occurrence of the stated condition but not otherwise. 3rd, delivery of a written promise in escrow or its conditional delivery to the promisee has the same effect as unconditional delivery would have if the requirement of the condition were expressed in the writing. 4. In the absence of a statute modifying the significance of a seal, delivery of a sealed promise in escrow or its conditional delivery to the promisee is irrevocable for the time specified by the promisor for the occurrence of the condition, or if no time is specified, for a reasonable time. Section 104, acceptance or disclaimer by the promisee. 1, 2, and 3. 1. Neither acceptance by the promisee nor knowledge by him of the existence of a promise is essential for the formation of a contract by the delivery of a written promise which is binding without consideration. 2. A promisee who has not manifested assent to a written promise may, within a reasonable time after learning of its existence and terms, render it inoperative by disclaimer. And 3rd, acceptance or disclaimer is irrevocable. Section 105, acceptance where return promise is contemplated. Where a conveyance or a document containing a promise also purports to contain a return promise by the grantee or promisee, acceptance by the grantee or promisee is essential to create any contractual obligation other than an option contract binding on the grantor or promisor. What amounts to acceptance of an instrument? Acceptance of a conveyance or of a document containing a promise is a manifestation of assent to the terms thereof made, either before or after delivery, in accordance with any requirements imposed by the grantor or promisor. If the acceptance occurs before delivery and is not binding as an option contract, it is revocable until the moment of delivery. Section 107, creation of unsealed contract by acceptance by promisee. Where a grantee or promisee accepts a sealed document which purports to contain a return promise by him, he makes the return promise. But if he does not sign or seal the document, his promise is not under seal, and whether it is binding depends on the rules governing unsealed contracts. 108, requirement of naming or describing promisor or promisee. A promise under seal is not binding without consideration unless both the promisor and the promisee are named in the document or so described as to be capable of identification when it is delivered. And lastly, section 109, enforcement of a sealed contract by promisee who does not sign it or seal it. Okay, so then we wind up in Chapter 5, the Statute of Frauds. I'm sorry, 109, I didn't finish reading more than the title. The promisee of a promise under seal is not precluded from enforcing it as a sealed contract because he has not signed or sealed the document unless his doing so was a condition of the delivery, whether it or not the document contains a promise by him. So, like I said, Chapter 5, Statute of Frauds is now the topic of conversation. And then we actually moved through that entirely in our last recording into the unenforceability on grounds of public policy and had just entered the scope of contractual obligations, which got us to and through some input on parole evidence. And in section 214, again, of the Restatement of Contract second, within, I'm guessing, chapter 7, scope of contractual obligations, we read evidence of prior or contemporaneous agreements and negotiations. Section 214, agreements and negotiations prior to or contemporaneous with the adoption of a writing are admissible in evidence to establish A through J. So I want to say these are exemptions from the parole evidence rule. Is if you are using this evidence, it is admissible in court to establish the following. A, that a writing is or is not an integrated document. B, that the integrated agreement, if any, is completely or partially integrated. C, the meaning of the writing, whether or not integrated, which is interpretation. D, illegality, fraud, duress, mistake, lack of consideration, or other invalidating cause. And E, lastly, ground for granting or denying rescission, reformation, specific performance, or other remedy. Section 215, contradiction of integrated terms. Except as stated in the preceding section, where there is a binding agreement, either completely or partially integrated, evidence of prior or contemporaneous agreements or negotiations is not admissible in evidence to contradict a term of the writing. Section 216, consistent additional terms. Evidence of a consistent additional term is admissible to supplement an integrated agreement unless the court finds that the agreement was completely integrated. An agreement is not completely integrated if the writing omits a consistent additional agreed term, which is A, agreed to for separate consideration, or B, such a term as the circumstances might naturally be omitted from the writing. Section 217, integrated agreement subject to oral requirement of a condition. Where the parties to a written agreement agree orally that performance of the agreement is subject to the occurrence of a stated condition, the agreement is not integrated with respect to the oral condition. Section 218, untrue recitals, evidence of consideration. A recital of a fact in an integrated agreement may be shown to be untrue, and 2, evidence of is admissible to prove whether or not there is consideration for a promise, even though the parties have reduced their agreement to a writing which appears to be a completely integrated document. Makes sense. Topic 4, scope as affected by usage. Section 219, usage. Usage is a habitual or customary practice. Usage relevant to interpretation, section 220. An agreement is interpreted in accordance with a relevant usage if each party knew or had reason to know of the usage and neither party knew or had reason to know that the meaning attached by the other was inconsistent with the usage. Number 2 of section 220. When the meaning attached by one party accorded with a relevant usage and the other knew or had reason to know of the usage, the other is treated as having known or had reason to know the meaning attached by the first party. Section 221, usage supplementing an agreement. An agreement is supplemented or qualified by a reasonable usage with respect to agreements of the same type if each party knows or had reason to know of the usage and neither party knows or has reason to know that the other party has an intention inconsistent with the usage. Section 222, usage of trade. A usage of trade is a usage having regularity of observance in the place, vocation, and trade as to justify an expectation that it will be observed with respect to a particular agreement. It may include a system of rules regularly observed, even though The particular rules are changed from time to time. Number 2, the existence and scope of the usage of trade are to be determined as questions of fact. If a usage is embodied in a written trade code or similar writing, the interpretation of the writing is to be determined by the court as a question of law. Number 3, unless otherwise agreed, a usage of trade in the vocation or trade in which the parties are engaged, or a usage of trade of which they know or have reason to know, gives meaning to or supplements or qualifies their agreement. Section 223, course of dealing. A course of dealing is a sequence of previous conduct between the parties to an agreement which is fairly to be regarded as establishing a common basis of understanding for interpreting their expressions and their conduct. Unless otherwise agreed, a course of dealing between the parties gives meaning to or supplements or qualifies their agreement. Topic 5, conditions and similar events. This too is rather important. A condition is an event not certain to occur unless its non-occurrence is excused before performance under a contract becomes due. Write that down. Effects of the non-occurrence of a condition. Section 225. 1. Performance of a duty subject to a condition cannot become due unless the condition occurs or its non-occurrence is excused. 2. Unless it has been excused, the non-occurrence of a condition discharges the duty when the condition can no longer occur. And 3rd, non-occurrence of a condition is not a breach by a party unless he is under a duty that the condition occurred. Section 226. How an event may be made a condition. An event may be made a condition either by the agreement of the parties or by a term supplied by the court. Section 227. Standards of preference with regard to conditions. In resolving doubts as to whether an event is made a condition of the obligor's duty and as to the nature of such an event, an interpretation is preferred that will reduce the obligee's risk of forfeiture unless the event is within the obligee's control or the circumstances indicate that he has assumed the risk. Unless the contract, this is number 2, unless within standards of preference with regard to conditions, unless the contract is of a type under which only one party generally undertakes duties, when it is doubtful whether A, duty is imposed on an obligee that an event occur, or B, the event is made a condition of the obligor's duty, or C, the event is made a condition of the obligor's duty and a duty is imposed on the obligee that the event occur. The first interpretation under those 3 alternatives is preferred if the event is within the obligee's control, and the first interpretation being a duty is imposed on the obligee that an event occur. In case of doubt, this is number 3, an interpretation under which an event is a condition of an obligor's duty is preferred over an interpretation under which the non-occurrence of the event is a ground for discharge of that duty after it has become a duty to perform. Because the courts prefer duties over conditions. They just do, I think. Here we are at section 227. Satisfaction of the obligor as a condition. Is that right? Section 229. Excuse of a condition to avoid forfeiture. I'm going to read these, but I think it's time. We're getting close to taking a break. Yes. And leaving off in conditions unless it would appear that, that there's only a page left. So, section 228, satisfaction of the obligor as a condition. When it is a condition of an obligor's duty that he be satisfied with respect to the obligee's performance or with respect to something else, and it is practicable to determine whether a reasonable person in the position of the obligor would be satisfied, an interpretation is preferred under which this condition occurs if such a reasonable person in the position of the obligor would be satisfied. Sounds subjective. test. Now, section 229, excuse of a condition to avoid forfeiture. To the extent that the non-occurrence of a condition would cause disproportionate forfeiture, a court may excuse the non-occurrence of that condition unless its occurrence was a material part of the agreed exchange. And section 230, event that determines a duty. 1. Except as stated in subsection 2, if under the terms of the contract the occurrence of an event is to terminate an obligor's duty of immediate performance or one to pay damages for breach, that breach is discharged if the event occurs. 2. The obligor's duty is not discharged if occurrence of that event A, B, or 3. A is the result of a breach by the obligor of his duty of good faith and fair dealing, or the obligor's duty is not discharged if occurrence of the event B could not have been prevented because of impracticability and continuance of the duty does not subject the obligor to a materially increased burden. 3rd, under the event that terminates a duty, the obligor's duty is not discharged if before the event occurs the obligor promises to perform the duty even if the event occurs and does not revoke his promise before the obligee materially changes his position in reliance on it. So chapter 10 is titled Performance and Non-Performance, and topic 1 is performances to be exchanged under an exchange of promises. Performances to be exchanged under an exchange of promises. This is section 231, and it is time to take a break.